Hello, and today I'm talking with Joe Greenlee, and he is the litigation director over at the NRA. And we're going to talk about a couple of things that are going on with the NRA and some litigation and different moves and things that are happening. Joe, how are you today?
I'm doing well. Thank you very much for having me.
Yeah, it's a pleasure to finally get you on the line and have a chat with you about all the things that are going on. Maybe just get my readers and my viewers and listeners a little up to speed, a little bit more about who's Joe Greenlee, what you're all about, what you're doing, because I know you wear a lot of hats and you do a lot of things.
Sure. I'm the litigation director at the National Rifle Association Institute for Legislative Action, focused largely on litigation, directing all the cases that we have. And then I write a lot of legal scholarship. I think I published recently my 18th scholarly article, which usually focus on the history of the right to keep and bear arms. And previously, I've been here about 14 months. The 5 years before that, I spent at the Firearms Policy Coalition as the senior attorney and director of constitutional studies. And then the 5 years before that, I was in general practice taking, as much Second Amendment work as I could, which typically came from Second Amendment Foundation and then working alongside Dave Kopel on various briefs and law review articles.
Sure, and you've got quite quite a pile of work that's been getting done too, from what I understand. And we'll get to some of those briefs and the things that you've been up to. My first question: what do you love about doing Second Amendment related law? Like, what do you love about this?
Well, so, always have loved and cherished the right to keep and bear arms. And it so happens that right now, I was really born at the perfect time in American history to do Second Amendment law and defend, kind of permanently define the Second Amendment through the courts. Because through the first, 200 roughly, I don't know, 25 years, the courts largely ignored the Second Amendment. And then came along Heller in 2008. And then we got a bunch of bad case law after that up until 2022 when New York State Rifle Pistol Association versus Bruin was decided. And the Supreme Court kind of reset Second Amendment litigation. So from now, 2022 until really 20, maybe 40, 2050, will be the time I think in hundreds of years when they look back at when the scope of the Second Amendment was defined, they will be looking back to this period, which just so happens to be when I'm alive and hopefully still working in this field throughout that time. But so it's just very fortunate and very neat to be able to be a part of that kind of permanently defining the scope of the right.
Sure. No, that's great. And now with the NRA, and you just said you're basically just celebrated about your 1 year anniversary, a little bit over that, right? So you've been with the association for a bit now. What has that experience been like for you? How's NRA-ILA treating you?
Yeah, it's excellent. I couldn't be happier. Could not be happier here. It's really exceeded my expectations, and we've been focusing on just becoming as active as possible. NRA's always been very active in litigation. They got kind of a reputation for not being active, I think because they weren't putting their names on cases. People would look at the caption. For example, New York State Rifle and Pistol Association versus Bruin was an NRA case. NRA, organized and funded and litigated all the way through, but it doesn't have NRA on the case. So a lot of people, even people who follow Second Amendment litigation and Second Amendment news, don't realize that was an NRA case. So they've always been active, but nevertheless, we are trying to maximize our activity and file, a lot of cases wherever we can, and then be especially active filing amicus briefs supporting other groups' cases. So that's been the focus here.
Yeah, and that's something that you bring that up. It's great that you do, and I've noticed this because I get all of the the releases for the briefs that are coming out from all of the different organizations, and something that I started to notice probably mid last year is, oh wait, we got NRA is co-plaintiffing with this group and NRA is co-plaintiffing with that group, and it's nice to see that the name is going on the briefs and getting that done. And most recently would have been over the last couple of months, meaning the Colorado case, right? So you guys were the leader of the the Colorado case. You want to talk a little bit about the what was going on there with the excise tax and everything?
Sure, sure. Although I'll quickly note for our co-plaintiffs that, we're all bringing it together. We
Sure.
don't want to act as if we, took the lead and dragged others along or anything like that. But we filed that one along. Well, first of all, Colorado has a recently enacted 6.5% excise tax on all firearm and ammunition sales, much like California. Colorado tends to follow California these days, unfortunately, in a lot of areas. And California had enacted an 11% excise tax on firearm and ammunition sales. So largely the same group of us filed the challenge to California's. I don't know, maybe last October and October 2024. And then this time it's a Firearms Policy Coalition, Second Amendment Foundation, National Rifle Association, and Colorado Shooting Sports Association. And we all got together to challenge this law.
No, I think that's great. And I misspoke. I saying the lead, you know what? The NRA's press release was the first one that I got. So that's just me misspeaking there. But I think it's great. So now you're talking about briefs. How many briefs have you written since you've been with the NRA-ILA? I mean, I think that you're like a machine. Do you sleep? Are you a vampire?
Well, I do have a bad case of insomnia, but which does seem to benefit my work until, I pay dearly for it. But yeah, I appreciate you noticing. We file last year, I think we had 15 amicus briefs, which was the most of any pro-gun organization. I think it's Giffords gets a lot of pro bono work from like 29 different major law firms, so they're hard to compete with. We haven't been able to pass them yet, but yeah, most briefs last year amicus briefs, and this year we're on pace to far exceed what we filed last year. And then additionally, we're taking more cases in-house to try to part of our efforts to increase how much work we're doing, how many cases we're handling. We're bringing a lot more work in-house. So in addition to the amicus briefs, we're writing taking a lot of cases where we're counsel on the case and litigating it ourselves.
So speaking of cases and being a co-plaintiff and being involved, there's a really, really exciting case out of New Jersey that you absolutely have to tell me all about, the suppressor case. What is going on with this?
Yes, so yeah, I'm very excited about this one. So we just filed, we being the NRA, along with the American Suppressor Association, the Second Amendment Foundation, Safari Club International, Association of New Jersey Rifle and Pistol Clubs, and New Jersey Firearm Owners Syndicate, all together have filed this case challenging New Jersey's prohibition on suppressors. This was filed in the New Jersey District Court, and I expect will eventually make its way up to the Third Circuit Court of Appeals. And really excited about this one for two reasons. At least, first, these groups have been wonderful to work with, all those groups I just mentioned. When you file a case like this, it's really like entering into some kind of a long-term relationship, because these cases can take many years to litigate. So you want to make sure that you file with groups that you really enjoy working with. And honestly, I think this is the most fun I've had helping to put a case together, because all these groups have just been wonderful. There's been no hiccups or anything along the way. They've been great. And so that's fun. And then secondly, I'm excited about it because I think we have a really strong case. There's just nothing close to a historical tradition of regulation that justifies prohibiting suppressors. And that's what that Bruin case I mentioned, the Supreme Court said that's what's required for a Second Amendment regulation on Second Amendment rights to be upheld. So I think it's a case we should win, and yeah, really excited to get that one filed.
No, I think it's great. And the thing that I keep repeating about the suppressors in general is they're not dangerous, they're not unusual, and guess what? They're now in common use. So once you get past all of the minutia of everything else, there's nothing to really lean on to keep these prohibited. And obviously that goes extended to how they're handled federally in the future. So that's going to be interesting. So you mentioned the Third Circuit Court of Appeals. So now I'm going to talk about a case that's not an NRA case, but maybe you could, bellwether a little bit on it. It's an association case for, the New Jersey affiliate, ANJRPC, is we have the Siegel case, which was combined with Coons. So we've been sitting on this, was at the Third Circuit Court of Appeals we're looking at a year and a half now. Now, I know this isn't your case, but I want to talk to you a little bit about the Third Circuit Court of Appeals. What do you think might be going on there with those two cases in particular? And then I'll broaden the question out further about the Third Circuit.
Yeah, so well, first of all, that actually is there's two consolidated cases there, and one of them is NRA backed.
Right. Okay.
But yeah, but that's kind of what I'm saying, where you don't have any way of really knowing, because NRA is not in the caption. So that's a good example of what we were.
So that is what are you on Siegel?
Yes.
Okay, so look, everybody, news to me, because I've been following this stuff wicked closely, and I didn't know that was partially NRA backed. So everyone that's listening, so that's another NRA case. So go ahead, take over.
Yeah, well, yeah, I don't know what could be going on. We did just pass the year and a half mark from oral arguments. That's not unheard of. There's a case in the Second Circuit, Zerka, a prohibited persons case that I think it was argued like several years ago now at this point. So it's not unheard of, and it is a very complicated case. It's one of these Bruin response laws. So after Bruin, the Supreme Court in Bruin said everyone has a right to publicly carry firearms. And a lot of these states, especially the ones that may issue licensing laws, like what was struck down in Bruin, responded by enacting these laws that just make 20 categories of places throughout the state sensitive, so-called sensitive places where carry can be prohibited. And so they're very complicated cases, because maybe if, schools are in there, that might be a different analysis than, some of these laws have like beaches and parks. So it's hard to come up with a rule that some of these courts struggle to come up with a rule that just applies to each one, and they analyze each category separately. So it might just be that the court's giving it a lot of attention. But I'm not really sure. I'm not really sure what else it could be. It's been going on for quite a while.
Okay. Well, and the Third Circuit Court of Appeals is kind of an interesting circuit. And traditionally, I think we could say that it's, heavily on maybe, let's say, business law, because of states like Delaware, because of their incorporation laws, make it a good place for business to be registered. But the Third Circuit Court of Appeals may actually be an up and coming circuit to put out all of these Second Amendment cases. What's your view on that?
Yeah, I agree. I think it will be could be an ideal situation there, in the sense that a lot of these states that are not great for gun rights, let's say bad for gun rights, New York or California, for example, happen to be in jurisdictions that are not great for Second Amendment litigation. Judge Van Dyke in the Ninth Circuit. So California's in the Ninth Circuit, and just before Bruin, Judge Van Dyke of the Ninth Circuit wrote this dissent explaining that court had heard since Heller over 50 Second Amendment challenges, and the court upheld the gun control regulation in every single one of those cases. So it just so happens to be that a lot of times these kind of anti-right states are in jurisdictions where they're very hard to challenge the laws. And New Jersey will be an exception to that, because it's going to be a not great state for gun rights in a relatively favorable court. So the Third Circuit, it's got 14 active judges, and right now there's 2 vacancies. So as it sits right now, there's 12 judges, because 2 just entered retirement or senior status. And it's got 6, it's evenly divided right now, 3 Obama and 3 Biden appointees. So 6 kind of, what president appoints a judge doesn't always indicate how they're going to rule on gun rights, but it's turned out to be a pretty good indicator. Mm-hmm. And Trump judges are certainly, generally speaking, the most favorable to the Second Amendment. So right now it's 6-6 Republican and Democrat appointees, and 4 Trump appointees, and then one of the non-Trump appointee Republican appointees is Judge Hardiman, who's outstanding on Second Amendment cases. And then with those 2 vacancies, it'll be President Trump who can fill those. So it should be an 8-6 divide there with 8 generally favorable judges. And even the Democrat appointees, we saw many of them in the Range case join with the majority agreeing that Mr. Range should get it's a challenge to the federal felon ban. Mr. Range wasn't actually a felon, misdemeanor, convicted of a misdemeanor punishable by more than 2 years in prison, but he falls within the federal felon ban, and he was forever prohibited from possessing arms. And as I recall, there's a few decisions in that case, including a few en banc decisions, but I think in the most recent one, only 2 judges voted to maintain that permanent firearms ban for Mr. Range. And Judge I think it's Freeman, joined with the majority, allowing Mr. Range to get his rights back the first time. Then you have Judge Krause, who's I think very intelligent, well, obviously very intelligent, but really tries to get cases right. So she's not like automatically going to uphold any gun control law. I think she takes a close look and tries to get it right. So overall, I think generally, certainly relatively compared to other circuits, favorable court. And so New Jersey might be the ideal place to bring some litigation.
Sure. Well, and I think Judge Krause is on the 3-judge panel for the Coons and Siegel case as well.
That's right.
So we'll see what happens, So you said about New Jersey. So, and there's a lot of frustrations. You hear all the murmurs from people in Massachusetts and New Jersey and a lot of these states where it is very difficult because we're Massachusetts in particular, because it's a bad gun state and a bad circuit, right? At least New Jersey, the circuit's slowly changed to where it's a little bit more favorable. Is it safe to say that the NRA is coming for New Jersey? Is that a message that we could put out there?
Well, we certainly intend to be very active in New Jersey, and I think it's going to be a very good place to bring cases. So I anticipate bringing a lot of litigation there over the next few years. And I should mention, we also have, right now, this is another case that has been consolidated with an NRA-backed case along with I don't want to get it wrong. I know it's definitely an FEC case, and I think theirs was brought with SAF, but we have a challenge in the Third Circuit to New Jersey's magazine ban and assault firearm. I think they're called in New Jersey assault firearm ban, which has been briefed at the Third Circuit. Oral argument should be very soon, I think within the next few weeks or certainly months here. And that one we could get a very good decision on.
Okay, sure. Yeah, no, I'm looking forward to that too. So that's also an NRA case. Another news flash to me. We probably should just talk about this offline and give me a list because this is crazy. So I'm going to say that maybe it's not a full-on declaration of war against the Garden State, but you definitely are giving people something to bang their shields over, right?
Yes, well, absolutely. I invite anyone reaching out, letting me know about laws that they think are infringements, because I think it's really the ideal state for litigation going forward with just, hostile, very anti-right state as far as the Second Amendment goes, and a fair court that you can get a, fair hearing before.
Sure. And I just got a couple other things here before we wrap up. And we were talking about some of those briefs that you did, and we also talked about sensitive locations. So that was also a recent brief that you guys filed was in Hawaii, right?
Yes, involving Hawaii's Bruin response law, but it's a certain aspect of it at this point. Sorry, do you want to finish? I kind of cut you off.
No, I'm letting you talk because you're the expert.
Sorry, I kind of jumped in there. Yeah, so Hawaii has one of these Bruin response laws, where the goal is to just make carry as impractical as possible so people don't bother. And then if they can't carry anyway, maybe they don't even get a firearm in the first place. And so Hawaii, I forget how many places each state designates as sensitive places, but they do all that. And then they also have a provision that a few of these states have, which is it's like the private property default rule. I think Rob Romano very cleverly named it the vampire, coined it the vampire rule, because in old literature, vampires couldn't enter unless they were invited in somewhere. And that's how these laws treat concealed carry permit holders. So if under these laws, if there's a publicly accessible private property, so think like a gas station or a grocery store, fast food restaurant, you can't enter as a carry permit holder with your firearm unless they have a sign or somehow expressly provide consent that you're allowed to carry a gun on the property. So they need to kind of put up a guns allowed, we allow carry here sign, which of course the purpose of that is to make carry not even worth going forward with, because you can't actually enter any places with your firearm. So that part, the plaintiffs in this case challenged that law, the Hawaii law, and the Ninth Circuit upheld that private property default rule. And it's the First Circuit, even the Second Circuit said that's likely unconstitutional, but the Ninth Circuit said no, it's probably okay. So the plaintiffs petitioned the Supreme Court to hear the case on that issue, and then also on whether 1791 or 1868. That's a whole nother issue, but the Supreme Court has twice acknowledged that there's some debate over whether, when we look to historical tradition, should we focus on the public understanding of the Second Amendment in 1791 when the Second Amendment was ratified, or 1868 when the 14th Amendment was ratified, which then made the Second Amendment applicable ultimately to the states. And so the petitioners asked the Supreme Court to address those two issues. And then we filed an amicus brief along with, there were 10 total groups on the case. And I need to give Kostas Moros special recognition for his incredible work on that brief. But we filed that, just making the point that this really is designed just to prevent people from carrying in the first place. And also there's no historical justification for it. And then the Department of Justice filed, so the United States filed an amicus brief also supporting the cert petition, which is, outstanding. We have not seen much of that in any of that in Second Amendment litigation that I can think of. And, nobody, as good as our brief was, and proud as we are to be a part of it, I don't think any brief can have more of an impact than, especially at the petition stage, than a brief from the United States. So that was really exciting to see, and hopefully helps to convince the court to take the case.
Sure. No, I think that's great, and showing that all of the reform and things that the Trump administration says they're interested in participating in, they are participating. It's just only been a little over 100 days, so it's not like walking on water happens overnight. And I think it's important to note that the Third Circuit Court of Appeals, I believe, twice affirmed that 1791 is the applicable time frame. So for all those cases that are going on in the Third Circuit, they are looking at 1791. That's correct, right?
Yes, although it was kind of the same case. I think that was the Lyra case. I believe you're referring to where they said 1791, and then that case got up to the Supreme Court, sent back to the Third Circuit, and they said 1791 again. So yeah, 1791 in the Third Circuit, and most federal circuit courts are coalescing around 1791, the majority of them at this point. But still, you have courts, like Second Circuit seems to favor 1868, at least when it wants to, and the Ninth Circuit favors it, at least, when it wants to. So it would be really helpful to get a decision. And in the meantime, if the Supreme Court doesn't weigh in, you get two different, the understanding, more restrictions were tolerated certainly in 1868 than 1791. So you end up with kind of 1791 reflects a greater, more robust appreciation for the right. And so you get kind of two different Second Amendments in different parts of the country. And I don't think the court can tolerate that for forever.
No, not at all. Joe, I definitely appreciate your time. Is there anything that I've left on the table that we need to get out there, discuss? Is there anything on your mind that you want to tell everyone that's listening in just about the work that you're doing, about the NRA, NRA 2.0, anything at all? What is your message?
Yeah, so I guess my message would just be that we're being as active as possible, trying to do as much work as we possibly can on behalf of our members and Second Amendment supporters, and very, happily and eagerly working with other groups as much as we can. I think on 9 of our last 10 cases we filed, we're working with other groups, including on the one we mentioned earlier. We have, we're working alongside 5 other groups on that one. So we're trying to do everything we can to bring everyone together and, kind of pull in the same direction here, and it's been going well, and I hope people are noticing.
Joe, I thank you so much. And what is the best way for people to follow you or stay abreast of what's going on? Is there, what's your plug? Is there some socials that you do? Do you have spicy tweets like Costas, or not really? Or
No, I'm only on LinkedIn. That's my only social media, and I don't think I've ever posted on there. So I'm not very exciting online. But if you follow NRA-ILA's legal alerts, then you should be hearing from us every other week at least, with some kind of update on some new brief or case we filed. So I encourage everyone to do that.
all right, Joe, thank you so much and have a fantastic day.
Thank you very much for having me.